And let's get started with the top story that we are tracking at this hour. Now, the United Christian Forum has filed a PIL in Karnataka High Court challenging the anti-conversion ordinance passed by Karnataka Assembly in May this year. The PIL states the ordinance betrays ideals of the Constitution of India and principles of secularism, thereby inciting hatred against the minority communities. The conversion bill, though passed in Assembly, is not yet approved by the upper house. The Karnataka High Court, meanwhile, has sought a response from the state government on this issue. Let me first go across to Neha, who's joining us right now. Neha, obviously, there has been a lot of controversy and, importantly, a lot of opposition with regard to what this bill, in fact, entails. But if you can take us through what this particular PIL says.
Well, absolutely, Avni. Let's go back a couple of months now. The Karnataka government had, in fact, passed this anti-conversion law, or the right to freedom of religion, in fact, that's being curbed upon over here. That's what the PIL really talks about. Now, in the PIL too, of course, the petitioners over here have very categorically gone on to mention that, this doesn't really uphold the fabric of secularism that's being practiced in our country today, that it's an infringement upon their basic rights. Now, also important over here to mention that the direction of the relief that they've sought from the Karnataka High Court over here, in fact, being the fact that the court pass an interim order and, restrict the government from making any arrests under this provision right now. And that's precisely what they're looking for. So as far as the government of Karnataka is concerned right now, we understand that the law minister, in fact, who spoke with me a little while earlier, mentioned that they would, of course, be responding in the next 4 weeks with all of their objections. But the government over here has gone on to maintain its stand that, this particular law that's actually been brought in right now is constitutional, that it doesn't really go against any of the sections of the Constitution today. But this is what has been contended in fact, the PIL that's been filed over here.
Thank you, Neha, for getting us all of those details. Obviously, this is a very contentious issue. We'll have to see how it really plays out in court. But on that note, let's get in some more perspective. KV Dhananjay, Advocate, Supreme Court and Karnataka High Court, is joining us here on the broadcast. Thank you very much, sir, for speaking to us. Your first, reaction to this. Clearly, the Karnataka government thinks that there is no way that the Constitution is being, clamped down upon here. But the thought behind this is to clamp down on forced conversions. There seems to be a lot of ambiguity in what constitutes that forced conversion and who classifies it as well. And when does it begin to infringe on the right to freedom of religion? What is your own perspective?
Well, if the government wants to prevent conversion from Hinduism into other religions, and also because the fact of conversion gives it a great sense of insecurity, and they want to come out with a law that would stop that, then this is the kind of law that they will come out with. But however, the Karnataka government will have to be somewhat insensitive to the fact that conversions, in fact, have been taking place all along, not just after the Constitution of India came into force, but much before that. For centuries, conversion has gone on. So I think the Karnataka government's anxiety is quite reflected in this law, and this law, according to me, does not stand the prospect of being, upheld by any constitutional court, provided, however, that those who approach the court will have to be a bit more open and then direct about how this law affects them. Now, what we understand is that Christian groups have gone to the High Court of Karnataka, and the easiest way for the government to get over the challenge is to say that this is religion neutral, and Christian groups cannot come in and complain that they are somehow more intensely affected by this law, because in this law we are not saying that any particular religion will in fact be targeted, but instead we have made it religion neutral, and it is that argument that probably might save the Karnataka government in this case. So one would have expected that people who go to the courts make things more obvious and then say so. In the sense, what's happening is the Christian groups have gone to the High Court. They could have openly said that it is Christian groups that in fact would be more intensely affected by this, because conversion is more often happening out of Hinduism, that there are more people in Hinduism who are converting to other religion, and are people in other religion who in fact would want such conversions to take place for whatever reason. Really, I mean, it's not like, you have to frown on that, because the Constitution doesn't frown on that. The Constitution expressly recognizes that there will be conversion. So in that view of the matter, a more direct argument perhaps will have the effect of letting the court decide these matters more meaningfully rather than in a vacuum, because this is a constitutional matter. It
Yes.
can't be decided in a very vacuum
Yes,
state.
absolutely. And that's, that's the real issue here, because the other aspect also, because we've not just seen this in Karnataka, other states have also talked about this. Possibly laws are, being made as well by each state. But the issue of the law itself, talking about this being misused, complaints regarding, for example, conversion can be filed by any family member or related persons, and it can cause a jail term of about 3 to 5 years. Wouldn't this then be a loophole that's easy to misuse? So if, for example, the family is against an intercaste marriage or a voluntary conversion from that perspective?
Absolutely. The law, if it is enforced to the letter, can prevent almost all conversions, because the law recognizes that a conversion would mean that there is a person to convert and there is an individual that is getting converted, because the law does not want mass conversions. Where conversion happens in a group, then that is outlawed by this piece of legislation, or rather an ordinance. So because the law wants prior notice declaration before conversion, and somebody must express the reason for conversion, and after conversion somebody must also give a declaration that conversion is complete, and in between there is this period of window where public objections are permitted, and then public objections would always mean that busybodies come in and say that, okay, fine, look, whoever is seeking to convert, or rather the person who is going to convert is in fact a zealot, or is a religious, this or that. And so this law, if it is going to be enforced in a manner that the paper actually would reflect, then there is simply going to be no conversion at all. And we are a very corrupt country, and all that this law would in fact also do is to increase corruption, because if somebody is so very keen to convert, then they will try to do this or that. And this is laws like this just do not make sense. And to understand how these laws operate, it's important for somebody to go to the court and then to talk about reality on the ground. Who is the one who's been converting, and why would they want to convert? So it's important for the Karnataka government to confront the realities of those who wish to convert en masse. Now, those who wish to convert en masse are very often very poor people. Now, our poverty is just going up and up and up. There are people who want to go over to the poor sections and tell them that, look, it's possible that you could in fact have a more decent livelihood should you consider converting to another religion. And poverty in fact makes any notion of wanting to have religious strength and all of that irrelevant, because poverty is really what matters to most people in their lives. And if somebody holds out a promise of, look, you please convert to this religion and you will be able to come out of poverty, who on earth can possibly object to that poor person wanting to migrate out of poverty? Who on earth can possibly object to, let's say, a Dalit, or let's to a sewage cleaner who might actually be promised by another religion to convert to that religion so that he will have a more decent livelihood? Nobody can. And the problem is, we are not looking at the fault lines in the religion, members of whom might want to convert to another religion. And we are not addressing that in the courts. Governments don't want to confront that. So this problem, therefore, will continue to fester. Making a law like this in a context of massive corruption is not going to help, because some people with resources will be able to tide over laws like this by bribing enough people through.
Yes.
But then many people will get caught, and that's in fact that's going to be a tragedy. And cosmopolitan, like we are in Bangalore, where 46% of the population of Bangalore alone is Kannadiga, 54% is outside. So it's possible that when you have diversity of this nature, there will be religious diversity, and when more people work in offices, more people go out and work, it's possible there will be a romantic relationship between individuals of different communities, different religions, and they want to marry. This law comes in the way of that. This law takes people to the back ages, and that is why it is objectionable. But we are only concerned that whoever wants to question it is not really presenting a more meaningful picture before the courts. The Christian groups that have gone to the High Court ought to say that the reality of several Christian groups is such that they wish to convert people from the downtrodden sections of Hinduism into Christianity, and Christianity would welcome liberation of the poor. And in that regard, they are justified in doing what they want to do, and the law comes in the way of that. An argument like that will shed more light on what really the government of Karnataka wants and how exactly are missionary groups affected. If we are not going to confront that reality, we will still simply be in the dark. We will have these arguments in vacuum, and we are going to go nowhere. Rajasthan, Madhya Pradesh, and two other states have come out with this, and we see in court debates that it's just in a vacuum. And that's a problem, because courts will not be able to properly solve these issues unless and until there is a forthright discussion about what's really going on in the name of corruption. What's really going on in the name of conversion.
Yes, absolutely. I think you've raised some extremely crucial and relevant points with respect to this entire issue and how we might see it progress and go forward on this. Going to be extremely contentious. But for now, thank you so much for joining us with your perspective.